Joining us right now is Tom Fitton of Judicial Watch. We spent a lot of time yesterday praising your work, Tom, and of course the great work of judicialwatch.org because, well, you fight the fights and you win a lot of those fights, including the 7-2 decision from the Supreme Court that lets candidates sue over election fraud laws and ballot counting fraud. In this case, it was a Republican congressman in Illinois where courts had said that he didn't have standing, Tom. If a candidate doesn't have standing to fight against election fraud, who does have standing? And obviously the Supreme Court agreed with you. Well done and congratulations.
Well, thank you. Our legal team did great work there. And, you know, when you think about it, it's like, well, why did we have to go to the Supreme Court to get this affirmed? But, you know, there's been this position by too many judges, frankly, in reaction to their anti-Trump animus, that they don't want candidates in court over election issues. And in Illinois, our client, Mike Boss, Illinois, they count ballots that arrive after 2 weeks after 2 weeks after Election Day. So the ballots come in 2 weeks after Election Day, they still get counted. And they're saying, well, you don't have standing to challenge that. It's absurd. And the court really essentially said, had a really broad view of standing in this case. They said, look, the candidate has inherent standing here. If a candidate doesn't have an interest in the integrity of an election, as you highlight, Larry, then who does?
You know, Tom, it was interesting. Justice Amy Coney Barrett, she concluded with the end result that the court came to with the majority opinion, but she wrote separately saying that, you know, the court should have actually taken a more straightforward, narrow path rather than kind of charting out a bespoke one, a novel rule of standing for candidates. Do you agree with that assessment? I mean, it's good that she joined with the majority, but do you agree that, you know, the court should have been a little bit more narrow in how they define candidates and give them standing?
No, because, you know, as the Chief Justice wrote, well, so does that mean someone who's running a volunteer campaign that doesn't have the expense, they're out? They don't have, quote, the pocketbook expense? And what's interesting is that was the Trump Justice Department's view. They were nervous about having a broad view that standing applied to candidates, which I thought was odd, given President Trump's aggressive efforts, I think, correct efforts to dispute the 2020 election.
Yeah. The 2020 election sort of looms over all of this, doesn't it? Because so many of those cases were dismissed before the evidence was even shown because of standing. I think most people don't know that. You know, they hear these teleprompter readers say, well, you know, this was all challenged in court and none of it, you know, stood ground. Well, no, because it was easily dismissed based on this.
Well, you know, it's interesting because, you know, back then it became, well, you can't challenge the rules here. It's too soon. Or you can't challenge the rules here. It's too close to the election. Oh, you can't challenge the rules. The election already happened.
Yeah.
And this decision says, you know, we're not doing that anymore. If someone has an issue, they can go in and challenge it, and we're not waiting till after the election when everyone's having a heart attack to go in and figure out, and then and only then, whether an issue is occurred.
We're speaking with Tom Fitton of Judicial Watch. You know, it's interesting that we didn't see 3 dissenters. We saw 2. So Justices Ketanji Brown Jackson and Sonia Sotomayor dissented, but not Elena Kagan. What do you read into that? And maybe why do you think Kagan joined with the majority opinion?
Because Kagan is, you know, relatively normal on some of these issues.
Relative in this case means compared to Sotomayor and Ketanji Brown Jackson, yes.
Yeah, I mean, you know, there's a partisanship sometimes on the court that, you know, that people get obsessed with, and this to me was a partisan dissent. And Kagan is an ideologue in many respects, but you remember, many leftists came in support of our position. And what's really interesting is what's going to happen next. Because right now we're in court with the Supreme Court right now trying to uphold the principle that you can't count ballots that arrive late after the election, because federal law sets an election day. And so that decision is, we're going to have the argument probably, my guess is in March. So they're all kind of looking ahead too, I suspect.
Yes. It's great. It's all the difference in the world. And we're finally getting into the game. Mark Elias and the Democrats have been fighting these fights in the courts forever. And Tom Fitton, I'm glad that Judicial Watch is fighting back big time and winning, by the way. Judicialwatch.org. Tom, always good to talk with you. And nurse that cold you've got. I can hear it in your voice.
It is me, just with a cold. Thank you.
It's going around. Thanks, Tom.
Thanks, Tom.